So I think we can continue. It is 9 o'clock. So yeah, I think with as Annelien said, please, for those that has just joined, there is a link in the chat that we want to ask you guys to please just complete. It's just the attendance register, and it's just for record keeping purposes, who attended and so on. We just want to yeah, just to have a look who joins and from which company. So yeah. Beth, I don't know if you want to share your screen so long, then I can introduce you so long to the workshop. So yeah, I think just Beth so first of all, welcome to everybody to the 5th workshop that we're presenting, and I hope that that you guys really find it worth your while to attend these workshops. So today's topic is regarding the injury on duties. How do we process it? What documentation needs to be completed, etc., etc. And Beth is from WCA Solutions, as you can see on the screen there. And they are experts in working with a compensation commissioner on behalf of companies. So dealing with the registration of letter of good standings, submitting the returns, also processing the claims on the injury on duties, getting the claim numbers, etc., etc. And yeah, they really do contribute a heck of a lot to the industry. So Beth, very warm welcome to you as well. So Beth is the director and manager of WCA Solutions, and she's got 17 years of experience in the field, so wealth of knowledge, and understands this field very well. And I think the contribution is significant, as it is a very difficult field to work with and to navigate through. So Beth, thank you for sharing your knowledge, and yeah, I hope that the guys will definitely benefit from the knowledge that you're going to share with us today. So Beth, yeah, I think over to you. Thank you.
Thank you very much, Gerard, and thank you for the opportunity to share with you. As you mentioned, it is quite a difficult field to work in and to navigate through. Absolutely. And we hope that today's session will make it just a little bit more understandable and more, a little bit easier for everybody to be able to comply and have joy with the trying to get their logs sorted and claims registered, etc.
Absolutely, and I think Beth, just from my personal perspective as well, I think it's imperative as the and I'm sure you're probably going to touch on it, but I think not only is it just to get the claims registered, but also to ensure that the documentation is fully completed, etc., and everything is submitted, so that the claims can be paid out to the medical practitioners, because I think that's a problem throughout the industries, where the medical practitioners don't really want to deal with injury on duties anymore, as the experience with the getting paid has been a significant problem. So yeah, I think that's the value that all of this adds. So yeah, thank you very much. But over to you.
Thanks, Gerard. Yes, in part 2 of the presentation, we will touch on that, because our company has 2 sections. It's the employer services and then the medical service providers. So obviously we want to get the employers compliant and the claims accepted. It's important to have your claims accepted, not just registered. So yes, thank you so much. Right, okay, I'm going to start on part 1 then. It's regarding the COID Act and compliance in terms of registration and good standing. So, as you all know, the COID Act and its objectives are work-related injuries or diseases are governed by the Compensation for Occupational Injuries and Diseases Act 130 of 1993, as amended by the Compensation for Occupational Injuries and Diseases Act 61 of 1997. We all know the COID Act or COIDA. So that's just the complete name of the legislation. The objective of the COID Act is as follows as stipulated in the Act, to provide for compensation for disablement caused by occupational injuries or diseases sustained or contracted by employees in the course of their employment, or for death resulting from such injuries or diseases, and to provide for matters connected therewith. In other words, it provides for protection of the employee when they are injured on duty or contracted disease, so that they can get the correct medical treatment and, if necessary, compensated for their injuries. The COID Act ensures the right of the employee to be compensated in the event that he or she qualifies in terms of COIDA, and it also protects the employer from civil claims. Now, that's something that a lot of the employers are not aware of, is that the employee cannot sue them for damages as a result of an injury or disease that they have encountered whilst on duty. So the obligation of the employer to register, when a new company is founded, an employer has, as soon as an employer has appointed an employee, they have 7 days to register with the compensation fund after employing their first employee. So if we encounter a lot of companies that have already employed employees and they haven't registered within 7 days, and then they're afraid that they're going to get into trouble. We still advise register now, before an incident occurs. Normally, the compensation fund will not penalize an employer if they go ahead and register, even though they're late. If they found out, or if an event occurs where an employee is injured and they then are basically audited, then they will get into trouble. We've never encountered an employer getting penalized for registering late out of their own without being mandated by the compensation fund to do so. So when registering with the compensation fund, the employer declares what the main nature of business is. And this we'll discuss in more detail in a little bit. The registration can, in certain and most instances, be done online on the CF online site. And it's actually quite a simple process. It's not extremely intricate, as long as everything is in order and all of your information is correct. The following employers cannot register online and have to submit a manual registration form to the compensation fund, together with a whole lot of supporting documentation. And they have got a list. It's any entity that does not have a pay-as-you-earn number, sole proprietors and partnerships, trusts, non-profit organizations, schools, and churches. And I know within the agricultural sector, we do have a lot of trusts. So those normally have to be registered manually. So it's a manual process, and this does take quite some time. Okay, so who's considered to be an employer in terms of COIDA? An employer means any person, including the state, who employs an employee, and includes any person controlling the business of an employer, If the services of an employee are lent or let or temporarily made available to some other person by his employer, such employer for such period as the employee works for that other person. So if I have my general laborer who works for me on a permanent basis, and I decide that Gerard needs an extra laborer for a week, I'm still responsible for that employee for the time that he is working at Gerard's farm, let's say, for example. A labour broker who against payment provides a person to a client for the rendering of a service or the performance of work, and for which service or work such person is paid by the labour broker. So a labour broker, a contractor, anything like that. It's imperative that if somebody is performing work on your premises, you ensure that they are covered in terms of COIDA. So if you've got subcontractors working, you need to make sure that they are registered, because you can be held liable if they're working on your premises, if they're injured on duty. So in other words, anyone who employs one or more employees is deemed to be an employer. The nature of business. As mentioned earlier, the employer declares what the main nature of business is when they register the business with the compensation fund. This determines the assessment tariff that will be applied to the business. It's imperative that the nature of business is accurate and in line with the main running of the business. For example, there's a huge difference in the tariff of an administrative consultant and an engineering workshop. You also cannot declare that your main nature of business is administration, for example, and then when an injury occurs, the task that the employee was performing when he was injured was harvesting maize. So it has to be in line with the main nature of the operations that your business is doing. If an injury occurs and it's totally out of line, then you're going to get audited, and the business will get into trouble with the compensation fund.
Sorry, Beth. I just a question for general sake. So this is applicable on the letter of good standing itself. So the onus is on the employer or the business to ensure that those allocations and that information on the letter of good standing is accurate.
That's correct. When you get your letter of good standing, you will see it has the nature of business on the letter of good standing, and the onus is on the employer. The onus rests on the employer to make sure that that is actually in line with the operations that they are doing. This is especially applicable with the manual registrations because you don't self-select. So if you're doing a manual registration, describe in full what operations your business is doing. Okay. Right. So it's imperative that the nature of business is accurate and in line with the main running of the business. Okay, so we've had that, and let's carry on. So in this presentation, we're mainly going to deal with the compensation fund. There are other insurers, Rand Mutual and FEM, but we're not going to go in depth into them. We're going to mainly focus on the compensation fund. I know their ROE seasons, which is the return of earnings that you've got to submit, differs from the compensation funds, but for purposes of this presentation, we're going to focus on the compensation fund. So for the compensation fund, the ROE season opens on the 1st of April annually, and it's meant to close on the 30th of April. However, it's invariably extended This year we have had 2 extensions. The first extension was until the end of May, and then they extended it further, and it's been extended to the 30th of June this year. So this is the time period that employers are obliged to submit their annual return of earnings in order to prevent penalties and to be compliant. You can't have a letter of good standing and not have submitted your annual returns, etc., and more, as we will explain now. So a lot of employers ask, why do they have to? Why do they have to pay annual assessments? Why do they have to belong to the compensation fund? And setting aside that it's legally you're obliged to do it, in essence, the compensation funds are social insurance. So we do have, in this country, we've got social insurance, and a lot of people don't realize that we have. So SASSA isn't the only social insurance that we've got. We've got compensation fund, we've got road accident fund. So that means that people who are not in a position to be self-insured can have that bit of assurance that in the event of an injury, they will have medical cover, and then also they'll receive proper medical attention, and neither they or the employer are then severely prejudiced with regard to loss of earnings. Okay, so now that the employer is registered with the compensation fund, you submit your annual returns or your return of earnings. Bear in mind that the compensation fund, their year, so they'll have it currently where, or this ROE season, we submitted the 2022 return of earnings. And with SARS, it would have been the 2023. So this is something that also often confuses employers. They'll ask for your 2022 return of earnings, and that will be the period of 1 March 2022 to 28 February 2023. That's your 2022 assessment year. Just something to bear in mind, it works differently from the tax year. So the return of earnings is a declaration of what the provisional wages will be for your first year of business. You register, and then you're going to say, so let's say we registered a new business on the 1st of March 2022. We've got to declare what our provisional wages, what we think our wages are going to be for that first year of business. Then we will get an assessment invoice, and that needs to be paid within 30 days. After your first year, on an annual basis, the employer will declare what the actual wages was for the preceding year, as well as the provisional wages for the year ahead. So once payment is made, and it is allocated by the compensation fund, the letter of good standing will be available. It's very important that when making payment of your assessment, you use the correct reference number and only the reference. So don't add anything in. We often encounter employers adding something in, and then your payment will not be allocated, and you will not be able to get your letter of good standing. And it's a huge administrative battle then actually to get that the money is allocated to your account. Okay. So now we have a look at how the assessment amount is calculated. So this is where your nature of business has a major impact. As previously discussed, you're provided with an assessment tariff according to your nature of business. This will be a certain percentage rate. The assessment amount will be calculated by multiplying the applicable tariff rate by the total declared amount. This will then be your actual as well as your provisional. Okay, so bear in mind that on the previous year, you've already paid an amount for your provisional earnings. Okay, we're going to have a look at an example of a security company, ABC Security Company, and their assessment tariff will be 2.36% of the total wages. So their provisional assessment last year was 42,480, as they had made provision for wages of 1.8 million rand. Due to their business growing, they employed more staff than they anticipated, and the actual wages that they paid was 2 million rand. They've also made provision for a 5% wage increase, and therefore their provisional estimation will be 2.1 million rand. So you'll see here that their actual total was 2 million. The assessment on 2.36% will then be 47,200, but last year they paid 42,480. So the total outstanding for the current year is then 4,720. The year ahead, they've made provision for 2.1 million. And the assessment estimate at 2.36% would then be 49,560. Those two get added together, and that 54,280 will be the total amount that they would need to pay when they receive their assessment invoice from the compensation fund. Okay, so what does the employer include as earnings? Need to bear in mind that there's an annual cap that's set by the compensation fund. So this means that any employee earning more than the cap, the amount is capped at, so this year the cap was set at 506,473 Rand per employee. So you will only pay up to the maximum, up to that cap. Any earnings of a recurring nature, for example, regular overtime, annual bonuses, travel allowance, all of those things that are of a recurring nature, need to be included in the declaration. One thing that is excluded specifically is contributions to pension funds made by the employer. Right. Okay, now we're going to have a look at penalties. Now, we don't like penalties because it's money thrown in the water, and the compensation fund will automatically add penalties for late return of earnings submissions or payments that are made after the due date. So if you do not submit your return of earnings, make your declaration in the time period that is allowed by the compensation fund, you automatically get a 10% penalty on your assessment invoice. Also, if you have submitted your return of earnings in time, you've got 30 days to pay your invoice. If you do not make payment within those 30 days, an automatic 10% penalty gets added on together with interest, and they add interest on a monthly basis. And it's not a small amount. It's not a small interest rate. So it genuinely adds up over time. It can become a huge amount. You always remember that you can make a payment arrangement with the compensation fund if you're unable to pay the entire invoice. And how they work it is you have to make a payment of 20% of the assessment total within the due period, the period that it is due, so within those 30 days. Then you apply with your proof of payment and other supporting documents for a payment arrangement with the compensation fund. If you do not adhere to the payment arrangement, so in other words, if you're at all late with making one of your payments or something like that, the payment arrangement falls away. You automatically have penalties and interest. And then for future, you will not be able to make a payment arrangement ever again with the compensation fund. So they're very strict on that. If you've made a payment arrangement, you have to adhere to it. You have to keep to your side of the payment arrangement. Okay. But that option is there. And it's actually very helpful. It's very beneficial to a lot of employers, especially smaller businesses that have cash flow difficulties. It helps them to be able to pay their assessments on a monthly basis throughout the year. What happens when you make a payment arrangement is your letter of good standing is generated on a monthly basis. So it will be valid month to month, so payment to payment. You will then still receive a letter of good standing. You won't receive your letter of good standing for the whole year. It'll only be valid for the time that your payment arrangement is adhered to. So once you've made payment of your assessment invoice and the compensation fund have allocated the payment, your letter of good standing will be generated. Now, in terms of legislation, you have to be able to produce your valid letter of good standing at any time if requested by the Department of Labour for it. And many medical service providers are requesting valid letters of good standing in the event that an employee is injured on duty. So at the moment, we've been experiencing with a lot of our clients, the Department of Labour is on a campaign to audit a lot of businesses. They are physically going out to the business premises and requesting certain documentation that is required to be readily available. One of those documents is the letter of good standing. And then the other thing that we've been experiencing, especially with the bigger medical service providers like the hospitals and some of the ambulance services even, they're requiring a letter of good standing before they will treat your injured employee. So it's always a good thing to have a letter of good standing on hand so that if requested for it, you can immediately produce it. Okay. Your letter of good standing gets downloaded from the Compensation Fund's online site. And so that is the end of my presentation. I have left quite some time for some questions and answers because I know that I see there is already there's already a question. So it's from Piet Boshoff. We have 2 COIDA cases whereby medical negligence are suspected after back operations were done by a medical doctor. Will I be able to provide some guidelines? So that would be a totally different case. That would be a civil case. It would have nothing to do with compensation fund, as they would have to basically, I know there are procedures to be done. The first thing is you've got to report it to the South African Medical Association. But there's procedures that need to be followed, but it's not through the compensation fund. Unfortunately, that will have to follow a separate route. Okay, I hope that gives some light.
Beth, maybe just from my side, can you maybe just take us through the workflow in terms of the forms that need to be filled in, what the different forms are, what they mean in terms of occupational diseases, And then maybe also so all the VCL forms applicable. And then also what documentation do we need to provide the medical service providers, and what do we need to get back from them, et cetera. Maybe if we can just go through that process to make it a bit more practical for everybody's sake, in terms of what do we need to have on hand if we have an injury on duty, or to register occupational disease, et cetera. Maybe just in terms of that WC, the WCL forms, please.
Okay, so that's in part 2 of my presentation. My thought was just to get questions on the actual registration of the entity and the annual assessments, etc. And then I can start with the actual claim registrations and things like that. So if there's no further questions regarding the actual registration of an entity, or the the annual assessments, then we can continue to the actual claim administration.
Okay. Beth, I see there's another question in the chat. Any information on the draft for return to work? I don't know if that's also in your second part of your presentation.
If they're referring to returning to work after being booked off sick?
I believe so.
Yes.
Anne-Marie,
Yes.
I don't know if you can just maybe provide some background regarding your question. Okay. No, I think
There's a draft rehabilitation, reintegration and return to work regulations that will require companies to accommodate for employees' disability returning after they've been treated for their injuries, how we will have to accommodate their new needs, etc.
Okay, so I don't think that has been totally set out yet. I know that the compensation fund have for about 3 or 4 years now been working on rehabilitation. They've been focusing on rehabilitation of employees. So they've been focusing more on occupational therapy, physical therapy, etc. And then also I know that they have been looking into, let's say, for example, an employee is physically disabled after an injury, but would still be able to perform their duties if some minor changes are made at the place of work, that they were looking at assisting in that regard. I don't think that, as I understand it, the claim, the actual, I don't think that the intention is to make the employer liable for making major changes or things like that. I think it's more of a campaign of the compensation fund to make it easier for an employee to return to work, if that answers your question.
Yeah, thank you. No, they've stated there that you need to consider, you'll have to have a policy procedure in place for return to work and find new job opportunities for that person in your company if they cannot return to the normal duty that they had before the accident. Is there a way that I can paste a document for the regulation here for everybody's information? Yeah. Yeah, this is the specific draft. It's a regulation that is going to accompany the COID. I just wondered if I can share the attachment I've got.
Okay. The talks, the actual verbal talks that we've had, the presentations that we've attended, they have stipulated that, and I know one of the examples that they actually used was if an employee is physically disabled, that they are wanting to assist the employer in, let's say, making minor changes. For example, making a workplace wheelchair accessible, things like that. So yes, I can't further comment on that than this.
Thank you, Beth. I see Herman also just commented that the compensation for occupational injuries and diseases Amendment Bill 2020 has been signed into law according to the Presidency media statement issued on the 6th of April 2023. So, yeah, maybe Herman, if we can have a look at that from Agbiz Grain side, and then we can possibly just distribute that after the session as well. So thanks for that information. Yes, Herman, I see your hands raised.
No, sorry, that was a mistake, but yeah, I'll try and find the document and put it onto the chat.
Okay, cool. So that was supposed to be a thumbs up, was it?
Yes, it was.
All right. Okay, great stuff. No, thanks for that, Herman. Beth, I think happiness is. I think the rest of the questions we can maybe attend to after the session, giving the guys some time to think. Then yeah, then we can address that. So I think you can continue on your side then.
Okay. Right. So in part 2, we're looking at claims reporting and administration. So as we mentioned right at the beginning, there is a difference between reporting an incident and the administration thereof. Our goal is to get a claim accepted, not just to register a claim and get a claim number. We want to register a claim in such a manner that it is easily acceptable, so that compensation fund can adjudicate on the claim in such a manner as that they can find no reason not to accept the claim. All right. So first of all, we look at how the COID Act defines what an occupational disease or injury is. It's defined as any disease mentioned in the first column of Schedule 3 arising out of and contracted in the course of an employee's employment and a personal injury sustained as a result of an accident. Schedule 3 is a schedule annexed to the COID Act. So you'll find that right at the bottom of the, at the end of the COID Act. In layman's terms, any disease or injury that is a result of an employee performing their duty would be deemed an occupational injury or disease. In this workshop, we're going to be focusing mainly on injuries, as that is the most common occurrence in the workplace. Okay. Very, very important. What to do before there are any injuries. It's imperative that you know who your employees are. And I know this sounds ridiculous, but just within the last month, we had a farmer. The medical service provider contacted us and said this farmer has had a serious, one of his employees has had a serious injury. He's not registered. Can we assist with an urgent registration? Which we did. But then this employee who was not conscious needed medical assistance, and you've got to complete the employee's details, obviously, on your employer's report. And this employer did not even have a copy of the ID. He did not know the employee's proper names as the names appear on the ID. So, and this is not the only case like this that we've encountered. It does actually happen that people do not know who their employee is. They'll know him as Pete or whatever, you know, but they do not know who their employees are. And therefore, it's imperative that you know who your employees are. Have copies of all your employees' IDs handy. So as handy as you possibly can. I know that one of the requirements is that it's a certified copy of an ID. The medical service provider usually will assist just with a normal copy of an ID. To me, it's actually a ridiculous requirement because the compensation fund is linked to the Department of Home Affairs. So when we're registering a claim, if you enter the employees, the person's ID number, it self-generates the details. So it's linked to the Department of Home Affairs. Yeah, why it has to be a certified copy of an ID, I don't know, but that's one of the requirements. But have copies, normal copies of all your employees' IDs handy. Very, very important. If you employ a foreigner, make sure that he or she has a valid work permit and passport. If in the event that an employee who is a foreigner does not have a valid work permit, they are not covered by compensation fund. They're not covered for anything, any medical treatment or any compensation. Also, if their passport obviously has expired, is not valid. If their passport's not valid, their work permit's not going to be valid. But yeah, that is something. And then it is a little bit, it's also a manual process for claim registration, just as a side note, if it's a foreigner, because they've first got to make sure, even though they, obviously that foreigner is not linked to Home Affairs system, but they send all of the documentation through to the Department of Home Affairs, who then verifies the work permits, etc. Okay, so now your employee is injured whilst on duty. What do you need to do? So you'll need to complete an employer's report of an injury, which is the WCL2. You'll hear when a medical service provider is requesting documentation from you, they use the form's name, which is WCL2, and not always the employer's report, and then you go into a panic because you don't know what a WCL2 is, but that is an employer's report of an injury. Something that we encounter on a regular basis is that all the questions are not completed. Even if it's not applicable, we'll upload a form that has a question that has no answer in it. It's not applicable to that situation, but nothing has been completed in that question, and Compensation Fund will reject and say they need more information. This just makes it take longer, and it makes more admin to get the claim accepted. So if it's done correctly the first time, then it's more likely to get adjudicated on quickly, you know, so that the medical service provider can get their medical invoices paid, and also it's less back and forward to the employer, because the medical service provider is going to be hounding you and saying this claim's not yet accepted, and they start sending invoices to the employer, etc. So even if a question is not applicable, mark it not applicable. The Compensation Fund employees are dealing with thousands of claims every day. Make it as easy as possible for them to just go through it and accept the claim. Okay. So all 3 pages have to be completed. If you want the claim to be accepted quickly, make sure you give enough relevant detail. So don't just say he was driving a tractor when they ask what task was the employee performing. Okay. Expand a little bit. Say he was driving the tractor when he went over a bump and he fell off the tractor. Something like that. so that they've got as much information as they need to adjudicate on the claim. The medical service providers will require certain documents, and the documents are as follows. Excuse me. The employer's report, which is the WCL2, certified copy of the employee's ID or passport, payslip. Now, this is very important. Compensation fund is refusing to adjudicate on claims where a payslip is not attached. So they have to have proof, and if you can't provide a payslip, then a letter on a letterhead, on a company letterhead, stating that you as employer confirm that this employee is in your employ and that their monthly earnings are as follows, and then stipulate that. Okay, so if you don't have a payslip, then attach a letter of it, confirming employment, but the earnings has to be indicated. And we'll get to why this is so important in a little bit. Okay, so if they were traveling, then you have to attach a travel report, and also please answer all questions on the travel report. So let's say, for example, they ask on the travel report, has it been reported, and what is the police station, and what is the case number? And you don't yet have a case number, complete on the form awaiting case number or something like that. Anything that's blank, they throw out. They don't have the time to look and to see. So if it's blank, they'll throw it out. If you put in on the travel report awaiting case number, for the most part, they're going to accept that claim. Okay, if everything else is in order. An assault questionnaire. So if there's an assault, there's also a questionnaire that needs to be completed, the same as if it's an injury related to traveling. And we'll go in a little bit more detail on assault just in a little while. So your obligations as employer in terms of registering the claim. An employer must register the claim within 7 days of the injury. They're starting to clamp down. They're going to give penalties to employers that don't register their claims timeously. This must be done online. A lot of the employers do not know, and they are still sending in the claim documents and saying that we've submitted the claim. The compensation fund does not see an email or a manual dropping off of that claim as a submission. It has to be done online on the CompEasy system. They don't register emailed claims without a valid reason. So if you've got a passport, for example, then yes, they'll see to that claim registration. If there's a system down for an extended period and you've got screenshots, etc., then they'll do a registration manually from their side. Otherwise, they don't want to register claims. They require the employer to register the claims online on the CompEasy system. Okay. The medical service providers can be extremely persistent in requesting documentation and claim numbers, etc., due to historical non-payment. The medical service providers have had a really difficult time in the past getting payment from compensation fund. So there's a lot of medical service providers that just refuse to do injury on duties. They do not see patients as an injury on duty. They just, there's even hospitals that do not accept injury on duty patients. The medical service providers that do still treat patients with injuries on duty, I think as employers, we need to assist them in getting their claims paid as easily as possible. Most of the times that they don't receive payment, it's due to an administrative problem. So either the employer hasn't registered the claim correctly and it's not getting accepted, or the medical service provider is not giving sufficient medical reports or something like that. But let's, from an employer's perspective, and from an employer's side, just make it easier for the MSPs to get their payment so that they will continue to treat those employees that were injured on duty. Make sure also that you're not difficult with the MSPs, that you provide everything that they require so that you can ensure that they'll continue to treat your injured employees in future. There are some third parties acting on behalf of medical service providers who they require certain documents from the medical service provider, and they don't even administer on the claims if they don't have those documents. So if a medical service provider requests a certain document from you, supply it to them so that you can make it easier for them to get their payment. I see Herman put on a note here in the chat that MSPs should be registered on CompEasy as well to facilitate payment. That's absolutely correct. But in order to get payment, the claim has to first be accepted. So that's absolutely true. Yeah. Now we have a look at wages. If the employee cannot return to their duties, an employer is required to pay at least 75% of the injured employee's wages for the first 3 months after the injury. If they're still absent after 3 months, then they can claim directly from the compensation fund. The employer can still make payments of their wages, you know, for for as long as they feel like, they would like to assist that employee, and then they can claim that back from the compensation fund. My next point is the compensation fund are meant to refund the employer, but this does take a very long time. It's very hard to query it. The compensation fund actually have got not enough hands, my feeling is, to handle the refund to the employers, but after quite some time, the refunds do start to come in. And that's one of the reasons why the compensation fund requests the earnings, so proof of earnings, so that they can see what that employee's earnings were at the time of the injury, in order to, first of all, refund the employer. Second of all, if the employee is off work for more than 3 months, so that they can continue to pay the employee. And then also if it's a fatality or so that they know exactly what the earnings were, in order to determine the pension payable to the dependents of that employee. So the resumption report, the WCL6, is used for this purpose, and it also needs to be uploaded onto the CompEasy system with supporting documentation, which would be, for example, a sick note from a doctor. The resumption report gets uploaded on a monthly basis. So every month you've got to upload a resumption report on the CompEasy system. Okay, now we get to the CompEasy system, which we have a pet name for it, which is the Comp Difficult system. A lot of employers encounter difficulties with this system. So yeah, I think it is getting a little easier. They have made some updates, etc. But yeah. So the CompEasy system is used by employers to register claims and upload supporting documentation, as well as medical service providers to upload medical reports and medical invoices for payment. The employer is obliged to register once again. It's on the CompEasy system, and this has proven to be a tedious task. I know a lot of employers have battled to get registered, a profile registered on the CompEasy system. So they'll have a profile that's registered, but they can't link their organization to their profile. because each your profile is attached, I would like to say, on to your ID number. So each individual, it's an individual that has a profile, and then you link an organization, and that has proven to be quite a difficult task. One thing I'd like to say is don't give up. It does take a very long time, but just continue trying. As much of the work that we can do that is in the employer's hands or in your own hands and not in a compensation fund official's hands, it will get done quicker. You'll have more joy in getting claims registered and accepted quicker. Okay. So just to go back to that, this would be one of the reasons why you would be allowed, I would say, and to have a manual registration of a claim, is if you've registered on CompEasy as you've got your profile, but your entity won't link to your profile, then you can have screenshots of that and submit the claim. However, they don't have time to look at all of these claims. So this will take a long time, and then you're going to get a lot of questions from the medical service provider. You're going to get a lot of emails. You're going to get accounts. You're going to get threats, etc. Okay. So we're going to have a look at some most common scenarios. An injury at the workplace or site, a motor vehicle accident, and an assault. So an at-workplace injury, this is a normal injury at the workplace where, for example, a mechanic hits his hand with a hammer during the normal course of his duties. Something that I want to reiterate, or I want to just show as really important: when your employer is in doubt, register the claim. If you're not sure whether this is going to qualify as an injury on duty, register the claim. Let the compensation fund make the decision. Everything that you do, you need to be compliant. So you be on the right side. Don't make your own assumptions and make your own decision that this is not going to qualify as an injury on duty. Okay. So the only thing that you need to bear in mind is that the medical service providers will have medical costs. So if you're really doubting whether an injury is really going to qualify as an injury on duty, then maybe what I would suggest is that you take your employee to a government hospital first, or else have in mind that you might be liable to pay for the medical treatment that the employee receives. Okay, so that's something to always bear in mind when you're doubting whether this will qualify for an injury on duty. The medical service provider is going to have costs, okay, that might not be covered by the compensation fund. So exclusion examples, and this can bring in a lot of debate. On your way from your car to clock in and you fall in the parking area, that's not an injury on duty. Even though you were already on the premises, you had not commenced your duties yet. We've had instances like that. They've been rejected. It's been made clear by the compensation fund they're not on duty yet. Okay. Having lunch outside and they fainted. This is something that we've also encountered. They were sitting outside and having their lunch and they fainted. That's not within the scope of their duties, so it's not an injury on duties. Any pre-existing conditions. So an example of this would be something like an epileptic fit. They had an epileptic fit and they fell and they knocked open their head and now they're injured. It's not an injury on duty because it was caused by a pre-existing condition which had nothing to do with the scope of their duties. And then another one is they had a heart attack while at work. We've had queries like this where the employer contacts us and says they had a heart attack while they were busy performing their duties. It's not an injury on duty. That is, has to be, it's a medical condition. Okay. So we'll have a look at a motor vehicle accident. The employee is covered for injuries sustained in a motor vehicle accident while performing his duties. So let's say you have you've got an office where all of the employees come to work, and then you've got various sites that the employees travel to from the office. The journey from the office to the site will be covered. They will be deemed to be on duty or back to the office from the site. For the most part, an employee is not covered on their way to work from home or on their way home from work. I know there's, if an employer provides a vehicle which is paid for by the employer, it's not, the employee doesn't have to make any payment from their side. It's an employee is specifically employed to drive that vehicle and go and collect employees from their homes, etc. That will be covered. That is one of the exceptions to this. Okay, but for the most part, they are not covered from their way on their way from home to work or on their way from work to home. Okay. Assault. An employee is covered for assault that is in the performance of the employee's duties, like, for example, armed robbery. But employees are not covered for assault arising from a personal conflict. So, and this is claims that we've encountered before, where the one employee owes the other employee money, and that employee is not paying him, so he gives him a hiding. That's not assault arising out of their duties. Okay. If it's totally like an armed robbery, if it is within the course of their duties, they're injured by somebody assaulting them, then yes. We've had, for example, a nurse who is treating a patient, and they are that patient is under strong medication, and they hit the nurse or kick the nurse. That is deemed to be an assault, and an assault questionnaire needs to be completed, and that does fall within the scope of their duties. All right. Hijacking. Hijacking is an assault, even if the person is not physically injured. So let's say, for example, the employee is hijacked and they need to be treated for shock. But they weren't hit, they weren't kicked, they weren't shot, they were held by gunpoint. That would be deemed an assault, and that would be covered. Okay. Same as an armed robbery, they don't need to be physically injured for it to be an assault. Right. Yeah, so something that I would suggest is that you have a checklist. Each employer needs to have a checklist easily accessible to see, okay, if one of my employees are injured on duty, then we need this document, this document, this document. Okay, we have it all. Let's get the documents provided to the medical service providers, and so that we can have this claim adjudicated, and also so that the medical service provider, even though, something I need to say is, even though it is the duty of the employer to register the claim, the medical service providers still require all of the documentation. One of the reasons for this is if one of my medical service providers' invoices is not paid, but we've complied totally, in order to litigate against the compensation fund. In order to get payment of that invoice, I have to have all of the documentation. It's not enough for it just to be registered online and accepted on the CompEasy system. I just want to have a look here quickly at the chat. Okay, so yes, so John asked about walking up or down stairs during work and you fall and are injured. Yes, that would be deemed. So if I'm walking from my desk to the printer and I'm walking and I trip in the passage or fall up or down stairs, that would be deemed an injury on duty. If I'm on my way to the microwave to go and heat up my food because I'm on lunch, no, that's not an injury on duty. Does it fall within the scope of my duties? Okay. Yes, so if it's not your normal place of work, but you have to visit other sites, it would be deemed an injury on duty. So always think of it like this: does this fall within the scope of the duties? Was the employee expected to perform that task by their employer, and they got injured during the course of performing that task? No, it does. So, John, if the person works in an office normally but falls while going downstairs in his or her normal workplace, it does classify as an injury on duty. If you're walking, if you're traveling even by foot, is for the course of your duty, you need to go and speak to a fellow employee about work, and you're walking to their office and you fall, it does fall within the scope of your duties. Okay.
Beth, maybe just a question from my side. So I think a lot of people on this meeting, a lot of us have operations that are very remote. And I think the challenge with medical practitioners in those remote areas is quite, firstly, to find medical practitioners in remote areas that can treat our medical or our injury on duty. So if those doctors or medical practitioners do not do injury on duties, and I don't have a hospital close by, and the doctor demands cash before treating, how do we as companies go about it? Do we pay the doctor and then claim it back, or how would you suggest we deal with that?
Okay, so you can claim it back. However, your codes, so you're going to need to build a relationship with that doctor, because injury on duty codes, the tariff codes on the invoice differ from private and medical aid codes. They've got their own set of codes. They've got their own tariffs, which is gazetted. So you might end up paying 1,000 Rand and being refunded 400 Rand. So you need to talk to your doctor, make sure that the invoice is made out with the correct tariff codes. They can charge any tariff on those codes they want to, but the compensation fund will only refund the gazetted code tariff to the employer. The invoice has to be made out to the employer, and the proof of payment, so the receipt, needs to be made out in the name of the employer, and then the employer can claim that back from the compensation fund. Once again, long time for you to get refunded. You will eventually get refunded, but yeah, it takes a long time. You can go that route. Also, the other very important thing is, because a lot of the doctors that do not claim from compensation fund themselves refuse to complete a medical report as well. So you have to make sure that you still get the medical report and then the invoice with those details as I've explained now.
Okay, thank you. I see Piet has got a question. To clarify, the employee do reside in a neighboring town and need to travel to his or her workplace, which is 100 kilometers away. This travel duration cannot be seen as a injury on duty. I assume if they are in an accident or whatever the case may be.
Yes, that would be correct. So your travel from home to work, work to home is not deemed, you're not on duty for that time period. It would not be seen as on duty. That's correct.
Okay. Beth, just to add there, just also for clarification. So if the companies, let's say it's a specific operation and they working overtime, which is not normal for them to work overtime. There's a breakdown or whatever the case may be, and the company then sees it fit to maybe arrange taxis or buses or whatever the case may be to transport the people because of transport not being available at the time that the breakdown is finished. How do we deal with that in terms of the compensation fund?
Okay, that would be deemed on duty. That would be deemed an injury on duty. There's just extra requirements. So you would need a receipt made out to the company from the transport company, I would say, to say that they are conveying these employees on behalf of the employer. Yeah, there's just some extra requirements, but that would be deemed to be covered. Those employees would be covered for that journey.
Okay, perfect, thanks. Okay, Beth, I don't see any further questions in the chat though. I don't know if you've got a part 3.
I don't
Okay.
have a part 3. I've got part 1 and part 2.
Perfect. I think then, so I don't know if there are any other questions pertaining injury on duties. I think a lot of us our operations are in remote areas, so I think that always poses a challenge. Beth, I think maybe just something for clarification. What are the parameters in terms of taking a injured employee to a state hospital versus a private hospital?
Okay, Gerard. So it would be exactly the same requirements. The one of the things with the state hospital is make sure you get your first medical report. That is one of the challenges that we have from the state hospitals. They do have them, but have a little package of documentation. So if your employee gets taken to a government or any medical facility for that matter, have in your little package of documentation a blank first medical report and ask the doctor to complete it. Some of them will, others will say they'll do it at a later stage, but especially at a government hospital, I feel that you need to insist on getting that first medical report from the doctor. Everything remains exactly the same.
Okay, baie dankie vir
All of the requirements are exactly the same, whether it's a private, whether that employee is receiving private treatment or government medical treatment. I've just put a contact email address and our office number in the comments in order to yeah, so if you've got any query, if you think of anything at a later stage, you're welcome to query with us. We'll have a look if we can assist you. I see Ayanda says, when does the law apply the thin skull rule approach to a lodged claim similar to criminal procedure? Ayanda, would you just elaborate a little bit more?
Okay. Thanks. What I wanted basically to say, what usually would happen on a criminal procedure where an eventuality happens, what they would look into is to whether what would have been the total cause of that particular eventuality. Had something not happened, would it have happened if the event, if a particular event did not occur, would the eventuality have occurred or not? In that way, then it makes it quite easier even for a magistrate or a judge to make a decision when it comes to that, which is what they apply as your thin skull rule. Whether you would have known or not, it becomes immaterial, but the eventuality happened as a result of what a person would have done or an event would have happened. For example, if you were not gonna go work, would you had been involved in an accident? If there's affirmative that you would have been, then it will be taken that it does not really have an impact when it comes even on the side of either lodging a claim or lodging a case. But if the result is that had you not gone to work, you wouldn't have been involved in an accident, then the affirmative is that because the cause of that eventuality is because of you going to work.
No, Ayanda. So if I'm understanding you correctly, it has to be within the scope of your duties, and it doesn't have any.
Yes.
It doesn't have to have a causal. Remember, compensation fund is no fault. So even if the employee was negligent, they would still be covered. But because I can see, I think your question is leading to, if this employee was not going to go to work, he would not have been traveling. But they do not, they will not apply that rule. They will not. It has to be an injury which occurs during the course of the scope of your duties that you are performing. Does that answer your question, Ayanda?
Yes, no, it does.
Okay.
Thanks.
All right.
Thanks,
I
Beth.
see Werner asked can you advise on the TTD process? This is sometimes forgotten, that these claims can be lodged to the compensation fund. So that is what I explained, the resumption report, the WCL6, that forms part of the TTD process. So that's the refund for the employer for the wages that they've paid. If the employee is absent for more than 3 days, those first 3 months, the employer is obliged to pay the 75% of the wages. The TTD, temporary total disablement, that is the resumption report gets uploaded together with, first of all, the claim has to be accepted. The resumption report gets uploaded with the sick note, any medical reports that are applicable, etc. And that is the actual claim process. That's the process. I think that the compensation fund are working at streamlining that process at the moment. That's according to information from them. They would like it to be more streamlined so that the employer can get refunded the wages that have been paid by them to the employee, as well as, you know, after those 3 months, I know the employer always looks at it and says, oh, I've got to pay this employee now for 3 months while they're off duty. You know, after those 3 months, that employee needs to claim for themselves from the compensation fund. And I can tell you that it sometimes takes months or even years for that employee to get get paid. And in that time period that they're off work, not earning, you know, it can be really difficult for the employees. They can experience major financial difficulties. And you can just imagine each one of, you can imagine not getting your income for an extended period of time. So in order to make this process run smoother, if we can get the claims registered properly, get them accepted, it will expedite the process, the actual processing of the TTDs, and get those monies paid. I think that they are a little bit quicker, or our experience has been that they're a bit quicker in paying the employees themselves. That's another challenge that we have, is that the compensation fund doesn't want third parties assisting employees. And the reason for this is that there's a lot of fraud and their money gets stolen. So they'll receive remuneration, but that money has quite often in the past gotten stolen by third-party agents. So the best thing is, if an employee is off work for longer than 3 months, for them to go in themselves to the compensation fund and get the process of the TTDs and their remuneration sorted. Okay.
I've just got 2 questions. One is more question than the other. So let me start with this one. So in terms of occupational diseases, can you maybe just quickly run us through how to deal with occupational diseases? I think there are parties involved, like the occupational medical practitioners, etc. But how do we deal with it? So, because I think occupational diseases are often something that is not so familiar in terms of the processes that needs to be followed, rather than injury on duties that often are more often dealt with.
Okay, so it's the same process basically. In essence, it's a different form. It's a WCL1 form. Then obviously the employee will experience symptoms before the date of diagnosis, if I can put it that way. So with an injury, you've got a definite date of injury. That hammer hit the mechanic's hand on that date. Whereas a disease is normally something that is formed over a period of time, or it could be due to contact with, you know, if it's a contagious,
like a chemical substance or
something like that. Then there can be, but there will either be a prolonged contact, or it will be there will be a contact, but it can't always be determined exactly on what date. So that will be seen as the date of diagnosis. Will be, so the date on your registration, your claim registration, will be the date of diagnosis. So all of the medical documentation, there are more, you know, medical reports that are required. There's quite good guidance in the sense that when you upload, for example, you'll have your medical report, your first medical report for the disease. It also all depends on what kind of disease it is, because let's say, for example, I'm just trying to think of the name. So it's like I'm sitting at a desk and I'm typing, and I get a muscle disorder due to that. There's a different set of requirements as with a where you're exposed to a chemical. Hearing loss has a different set of requirements. That's why it's very broad. So each instance basically has its own requirements, and that's why I can touch on it, but each occurrence will have a different set of requirements. Normally, the medical service providers that are treating the employee will know reasonably well what reports are required for each diagnosis, if I can put it that way.
Then just, I think just regarding medicine, if an employee is injured, whatever the case may be, and they need medicine thereafter, how do we deal in terms of that? So just a practical question there.
Okay, that's a very good question, Gerard. So the majority of pharmacies do not claim from the compensation fund. If the employee is seen at a hospital, for example, normally they will provide TTO medication, to take out medication, to the employee, but sometimes they'll give that employee a prescription. So the employer can pay for the medication, then they can also claim that back from the compensation fund. But once again, the invoice from the chemist needs to be made out in the company's name. The company has to have a copy of the prescription, copy of the medical report on the same day as that prescription date. And then all of the other relevant claim documentation. The claim has to be accepted before the employer can claim that back. The receipt, once again, has to be in the name of the employer. Anything that you would like to claim back needs to be in the name of the company. Okay.
Okay, thank you very much, Beth. I don't see any further questions arising. Are there any last questions before we conclude? Let's see. Piet says drug or under the influence can claim be processed. Beth, I don't know if you just want to address Piet's question there.
Okay, yes. So remember that it's no fault. That would be there would be an internal investigation for the company. If it's done within the scope of the employee's duties, they would enjoy cover. Obviously, there would need to be then steps taken by the employer. Okay. At this stage, the compensation fund does pay for medical treatment of employees that are injured within the scope of their business. They do not, they haven't up until now rejected claims if there are situations where the employee is negligent or under the influence. Okay.
Thank you, Beth. I don't know if there are any other questions. I see, Wessel, your hand is raised.
Yeah, thank you. Thank you, Gerard. Maybe if all the questions is done, and you think it's applicable here, maybe you can just share with us just very shortly what we have in mind with the two indicators that we want to establish over time, what we mean for our Agbiz Crane members. Thank you.
Yeah, no, thanks, Wessel. I think, yeah, we've sort of mentioned it before, and I think we haven't really established the calculations yet and so on. So I think it's something for participation. But I think we've mentioned previously that our endeavor is to benchmark ourselves within the industry, and one of the best ways is to obviously calculate your lost time injury frequency rate and your total injury frequency rate. So yeah, I think if we can extend the request to you guys to maybe calculate those rates and maybe give it through to Annelien, Wessel, I presume it'll probably go to her.
That's correct. So we request from all our 12 Agbiz Grain members, and Jared, maybe we must just prepare a little template for them to submit that information. We have our own Agbiz Grain SHEQ committee. We can submit it to the SHEQ committee from each member, and then get it back on. I think you said it must be 2 times a year, at the end or the beginning, and then in the middle.
Yeah. So I think then we can establish a so the idea is then to establish a benchmark for the industry. Obviously, we'll have to have a look at what our frequency rate calculation is, whether we're going to calculate it on 200 or a million hours, 200,000 or a million hours. But I think Wessel, maybe we must send out a template, and then we can get the comments back from the 12 members as such. Okay, I think with that, Wessel, before we conclude, you asked.
Yes, Jared, can I continue?
Yes, of course. Yes, thanks.
I just want to thank everybody that's on this line. So we have 74 participants at the stage on this line, and I think Beth, also thank you very much for you that share that information to us. It's very valuable, and it seems to me it's a very topical point. I just want to and I also want to thank our Agbiz Grain SHEQ committee, because they are also helpful to assist us to identify those critical aspects in the grain handling and storage sector, which is important for us, but it also spans to the other sectors within the greater Agbiz. And then Plaas Media, who also sits in this meeting, that will give us a summary in the Agbiz Grain Quarterly, which is our magazine, on this workshop. And Beth, I think we will also refer to you for your contact details in the article. So it's very helpful to have a summary and to have something that we can go ahead. I want also to mention Santam Agri Hanley Cruiser for accrediting these workshops. It's so helpful, and we really appreciate it, because it gives everybody understanding of the importance, understanding of the quality. And Gerard is very quiet about it, but he's also attending as an panelist in our session in September, where it's about the insurability of the storage sector, and the insurability of the storage sector with these 2 indicators, and also each and every one of these SHEQ forum workshops actually showcase what we are doing in the sector. And Gerard, I want to, for you taking the lead from VKP, which is also Agbiz Grain member and Agbiz member, thank you very much. We really appreciate it. There's a lot of time going in that. And then I want to, also my colleague Annelien, without you, we can't bring everybody together, and the recordings and what you do assist us. Thank you so much for that. And then, and without everybody that spread the word of this forum to everybody that you know, and please have a good day. Then from my side, we really appreciate it. And thank you, Jared, again for you.
Thank you, Wessel, and once again, Beth, from my side too, thank you very much for setting this up. I know there's a lot of work that goes into that as well. So many things from my side, and everybody that attends. I hope it really adds value. I hope that it gives constructive information to take back to our businesses to implement and to ensure that we are compliant. Just the last point, there is the register, so please complete it. It's very quick. I think it's 3 or 4 fields that you need to fill in. So it's very quick. So please do that, so that we have that attendance register. If there are any questions, you're more than welcome to always email Annelien. and we can then, or you can actually email Beth as well directly. You're more than welcome to do that for assistance in that regard as well. So yeah, thank you very much, and I hope everybody has a wonderful week ahead. Enjoy.
Thank you.
Thank you. Thank you. Bye-bye.
Thank you, everybody.